represented every different variety of loss share bank, from small community banks that have done just one deal to large regionals which have done dozens of deals. And through that time, we've had the opportunity to be partners with our loss share bank partners through all the ups and downs associated with loss share administration and compliance. I'm happy to field any questions anyone might have at the end of this program, and I'm honored to be part of this panel.
Great. And last but not least, Jeff.
Thanks, Nadine. Jeff Azus. I'm a Senior Vice President at Hilco Real Estate. I've been in the real estate development, brokerage, and disposition business for over 18 years, with mostly specialties in dealing with non-essential assets. More recently as part of complex bankruptcies and working with a number of banks to dispose of their difficult to value and difficult to sell properties.
Great. So let's jump right into it. So judging by the folks that have participated in this webinar as an attendee and just their backgrounds, there's a lot of familiarity in terms of what an FDIC loss share arrangement is. And we'll be spending a bulk of our discussion talking about early termination opportunities and potential challenges. But just so we're all on the same page, Kay, if you could kick us off and just set the stage and just give us a framework for the FDIC loss share arrangement, and just we'll make sure everyone's on the same page.
Okay, great, thank you. Since we have some FDIC partners on this, please feel free when this is over to say where I missed out on something. But I thought it might interest all of you to know, to start out a little bit here, that the FDIC first entered into loss share agreements in 1991. And as of September 2014, they had executed 304 loss share agreements with assuming banks covering initial asset balances of over $216 billion. At the time that this report was completed, covered assets were down to just a little over 60 billion, but estimated savings compared to an outright cash sale of the assets exceeded $41 billion. So it's clear to see why loss share is an excellent option for the FDIC. It has proved, based on this, to be the least cost alternative. So as you all know, who are on here, because most of you are living loss share every day, as you know, commercial loss share agreements are generally for a period of 8 years for commercial and 10 for single family. And of that, for commercial, both of them, 5 years is a period which the FDIC shares in the losses, and then the last 3 years is the period that the FDIC gets the opportunity to recover some of what they have paid to the bank. All agreements are not the same. However, there are some basics which generally apply. And some of these differences are because each agreement is negotiated separately. In addition to that, there are some things that have evolved over time that older loss share agreements have that newer ones do not have, for example. But some of the basics that apply is that the FDIC pays the assuming institution 80% of losses, and those losses are defined as charge-offs on a loan or a loss on the sale of an asset. The FDIC will also reimburse 80% of certain qualified expenses, such as taxes, appraisals, legal fees, the cost of collection, other than administrative cost. During the subsequent recovery period, 80% of the net recoveries, it flips. 80% go to the FDIC of the net recoveries, with the remaining 20% going to the bank. All note sales require FDIC pre-approval, and bulk sales of notes are generally not permitted except under very limited circumstances, and those circumstances are really based on individual loss share agreements. The loss share portfolio must be managed by the assuming institution in the same manner as the non-loss share portfolio of assets. The resolution for each asset in the portfolio must represent the least cost alternative and be documented as such. And during the recovery period, assets must be managed as diligently as they are during the sharing period. And then last but not least, of course, there are numerous reports required, exams, oversight, evaluations. So all of these are generally the same. There will be some differences based on the individual loss share agreement. So, Naveen, I think that really covers just the basics of loss share without giving these folks on here today information that they are living with.
Sure. And so beyond sort of the factual framework of loss share and just the scenario that's occurred on many occasions with banks just over the last few years acquiring other banks with the assistance of the FDIC, it is sort of a new experience beyond an existing bank-FDIC relationship dealing with the loss share. And so just from our perspective, talking to a lot of banks, the relationship with the FDIC has been similar, but there's been some nuances associated with it. Not good, not bad, but what are some of the strategies you've been able to utilize in managing a successful relationship with an FDIC during a loss share arrangement that you could share? And then we'll build on that as we talk about early termination.
Okay, great. Well, I'm going to put this into the category of lessons learned.
Okay.
Some the hard way and some not the hard way. But I think all of these things are really important as what we found. And one of them is the term least cost alternative. It took me a while to get that. I understood the concept and we did all of that, but it took me a while to get that is really a mantra of loss share, or maybe the mantra of the FDIC. If you think about it, the decision by the FDIC to even enter into a loss share agreement versus other options that they have, that is based on the least cost alternative. And then secondly, if you decide to do an early termination and you go to the FDIC with this request, the decision made by the FDIC as to whether to go through early termination is also a least cost alternative. With respect to individual credits, when we talk about decisioning for individual credit resolutions, we have to be able to document that whatever we did is the least cost alternative to the FDIC. It will cost them the least. And generally what's in the best interest of the FDIC is also in the best interest of the bank. So, but I think that is a really important, it sounds so simple, but it's an important thing to remember. Secondly, second lesson learned is the relationship of trust with the FDIC. You have to have a trust relationship that is totally transparent with no gamesmanship. In my view, when you get involved in trying to skate around the edge without being open about it, you run into more problems. What I found and what we tried to do was to meet personally and frequently with our FDIC representative and keep them posted on our overall strategic plan and sort of noodle with them about, well, could we think about doing this? Could we think about selling judgments or what can we do at this point? And that was very helpful. We asked for feedback and advice and counsel, especially for out-of-the-box transactions. My experience is the FDIC will not give actual transactional approval unless it's a note sale because they're not required to do so. However, they are very good about telling you whether something will or will not fly. It is important for your representative to be an advocate for you, and that's not going to happen if there's not that relationship of trust. As we've already mentioned, note sales require pre-approval of the FDIC. However, OREO sales do not require pre-approval. one of the things that I did with respect to the trust relationship with the FDIC is that we did an auction, a national auction of several OREO properties. In fact, Hilco did that auction for us, did it highly successful. But we did this, and we talked to our regional FDIC representative first. We sat down with them and said, this is what we're thinking about doing. As we went through the process, we gave them a list of all of the properties that we were considering selling with what the reserve price was, and it worked out very well, and it was a good overall relationship with no issues. I think the third lesson learned is on resolution strategies for individual credits. Be creative. Think outside of the box. And everybody's portfolio is different, and there are a myriad. What I see frequently is you either renew and extend, and if that doesn't work, you foreclose. And there are many, many, many options in between those. Portfolios like these, or at least the ones I've been involved with, don't have too many opportunities for renewals and amendments as they are. So you have to think about things like discounted payoff, selling the bank's position wherever it is, in a foreclosure, for example, short sales, assignment of notes and liens, partial releases of liens and sale of collateral, global settlements, and then note sales, as we talked about. You notice I did not mention foreclosure. This is my own personal bias, but in my opinion, foreclosure is just moving an asset from one problem category to another. You have to do it. It should never be first choice. Okay. So another lesson learned, treating the portfolios the same. In the OREO auction that I mentioned, we had to be certain that we also sold properties that were in the non-loss share portfolio and that they would be about the same. So that's one of the things that we did. Document, document, document. Be sure you document. You have lots of people you're working with. They change jobs like everybody else does. And there's a lot of documentation, a lot of auditors, a lot of loan review examiners, a host of other people. So document everything and keep track of it. And then the very end of it, as we segue into the next part of this presentation, is it comes time for recovery. You're near the end of loss share, your assets are getting stale, and you have a lot more deficiencies and judgments, a lot of charge-offs. And the FDIC wants us to work these as diligently in a recovery period as we did when we were in the loss share period. And you can do this by signing people to work in-house on them, and I think that gets difficult because we never have enough staff to do that. You can place them with collection agencies or contingency counsel. And what I think we all have to be certain of there, a lesson learned, is to make certain that it doesn't end up costing more than what we expect to get back from it. And then the sale of notes and judgments, the bulk sale of notes and judgments. Bulk sale of charge-off notes is problematic, although I think it's still worth a discussion with the FDIC. Judgments can be sold. And then the very last thing here, the final resolution is to buy out your loss share agreement. So I think that, to me, is sort of a natural progression, Naveen, of how
no, that's great. So. And some very valuable and insightful comments. And I'm sure for many of the folks on the phone, whether through the FDIC or just on the bank side, they can relate to some of the lessons that you shared. So let's dive into early termination opportunities. Lori, if we may, can you walk us through why this is now becoming a hot topic for many banks that are in an acquiring institution role?
Absolutely. Thanks, Naveen. I'm so glad to hear Kay comment so clearly with regard to what she called the mantra of least cost alternatives. People also refer to it as the highest recovery or the highest net present value. That really is what has been the key to success for those banks that have had the best experience associated with being a loss share bank. And of course, exactly as Kay described, that focus on least cost alternatives doesn't apply only to the loss share banks, but it absolutely is the mantra of our partners on the FDIC as receiver side. Both parties are focused every step of the way on the least cost alternatives, and naturally that means that consideration of early termination, some people refer to it as a buyout, is just a natural next step in this process. So as a bit of background, over the years, I think many people know that the FDIC has undertaken what has really proved to be a very careful, comprehensive effort to develop and optimize a process for successfully terminating loss share agreements. They've conducted a series of pilot programs, and the most recent one focused on loss share banks with remaining covered asset portfolios not exceeding $50 million in unpaid balances, and that was $50 million on each of the single-family and commercial non-single-family portfolios. But the reason that this, as Naveen mentioned, is a hot topic now is that the FDIC has indicated its willingness, and I would say its enthusiasm, to discuss early termination with any loss share bank of any size, whether or not it's in the target group. And you might say, Lori, how do you know that? This definitely isn't inside information. This is evidence that anyone can know just by reading the media reports, because I think we've all seen a surge of successful early terminations, and because some of those have been publicly held companies, there's been a lot of media coverage of those. Most importantly, for purposes of this conversation, those early terminations that we've seen take place have been of every size, and some of them far, far above the pilot program thresholds. Some of those loss share banks that have bought out have actually included banks that have multiple failed bank portfolios. And if anyone on this team hasn't already read up about it, you might want to look up some of the coverage of the buyout, the early termination that was conducted by the Bank of the Ozarks and that conducted by Florida Community Bank. They're both great examples of the fact that there can be a meeting of the minds on this topic regardless of the size of the remaining portfolio. So very quickly to summarize, in its essence, an early termination is the price at which both parties, the loss share bank, the assuming institution, and the FDIC as receiver, it's the price at which both of them are willing to go forward naked. What does an early termination do? Well, to talk about what it does do, it terminates all going forward coverage for losses. It terminates all going forward sharing of recoveries. And very importantly, it terminates all going forward true-up obligations. The assuming institutions who might be listening to this call, you probably recall that Section 2.5 of your shared loss agreements includes an equation that would require a true-up payment to the FDIC if losses don't reach expected levels. Any obligations related to those payouts are terminated in their entirety by an early termination deal like those that we're discussing. Now let's talk very quickly about what an early termination does not do. It does not eliminate or terminate your purchase and assumption agreement. Your P&A stays in place because all that is terminated through an early termination are the two shared loss agreements, which are addendums. They are attachments to your purchase and assumption agreement. So all of the protections, including the indemnification protections that you have pursuant to your P&A, all stays in place. Another important point is that in the overwhelming majority of instances, the payments to date associated with early terminations have gone from the FDIC to the loss share bank. So the early termination amount is wired to the bank from the FDIC. There have been isolated instances to date where the early termination amount has been paid by the loss share bank to the FDIC as receiver. Two examples of that would be Florida Community Bank and EverBank. Obviously, the economics on this are going to change over time, As you move further down the life of your loss share agreement, it is more likely that the economics are going to tip towards a payment to the FDIC because of the impact of the recovery period. That would be the 3-year period following your 5-year anniversary. So just a few more key issues that I wanted to share before we move on to the next speaker. There are a couple of cautionary notes. If you're thinking of this in terms of sort of pros and cons, a couple of cons that should be high on your radar screen when you think about this is that, number one, the early termination, a successful early termination, will speed the date on which you take your accounting reversal of any of your remaining indemnification assets. That is a given. You're going to have to do that at some point. But if you do an early termination, you are going to do that perhaps sooner than you might otherwise have anticipated. Secondly, you do have to keep in mind the immediate impact that you will have on your risk-based capital as your assets move from being government guaranteed to being non-guaranteed. Very important to your accounting and finance team within the bank. Of course, I don't want to end up, though, without talking a bit about the pros. Obviously, there is a huge, huge pro associated with the cost savings that banks immediately realize associated with saving the costs of loss share compliance. You no longer have the obligations associated with your quarterly certificate filings, any annual loss mitigation reviews, any annual on-site reviews. All of those costs and obligations are immediately negated. Second, a second big pro I wanted to point out is your accountants will be doing the happy dance associated with eliminating your dual bookkeeping. You'll no longer be keeping track of GAAP values and your loss share values. That dual bookkeeping obligation goes away once an early termination is completed.
Great.
Naveen?
And there are a couple of follow-up questions that just came in when you were speaking, so I'll save those for a few minutes from now. So Jeff, if you wouldn't mind, we've been doing a lot of real estate work for banks, acquiring institutions, assessing the real estate holdings, and then coming up with some sort of solution to monetize their assets in unique value-driving ways, both before and after loss share agreements have expired. What are some of the challenges we face, and how have we overcome them to be creative to some of our banking clients? Maybe there's some tips you can share.
Sure. Thanks, Naveen. Yeah, we have been working with a number of banks in and out of the FDIC loss share and with other corporate sellers in the disposition of their REO and other non-essential real estate. Just a little context, these assets range from all types, land, residential, hotels, gas stations, restaurants, golf courses, you name it. We've been involved in every asset type. We specialize in creating more aggressive marketing strategies for each asset to maximize its exposure to the marketplace. Your conventional broker who might have been working on a number of these assets for some time, typically puts a sign up, lists the property on the web pages, and this isn't a knock. This is just and they wait for the buyers to kind of come to them. We like to get more aggressive and go find the buyers and bring them to our clients, and then create strategies to maximize the value in an accelerated time frame. This can be in the form of a call for offers, date certain bid deadlines, sealed bid, online auctions, and live auctions. And a lot of times with our bank clients, it's a combination of a bunch of those different strategies depending on where the asset kind of sits in their pool of properties they're looking to sell. A lot of the challenges that we've run into is many of these assets are very difficult to value. They've been sitting on the market with little activity for some time. They're vacant, not income producing. We do see a lot of land out there. A lot of times there's limited due diligence, or the due diligence is outdated, older environmentals or older surveys, all of which kind of tie into making these assets, difficult to sell and difficult to value. And kind of tying that into the early termination discussion, it's very important that as you're evaluating your options, and evaluating early termination, that understanding the real value of these assets is extremely important as it comes down to what you're going to agree to with the FDIC. Obviously, it has to be a mutually agreeable terms so that both sides are happy, and the value of the underlying assets is very important. We've found that if you rely too much on the current appraisals, those don't always give you a real accurate value estimate. Appraisers look at things a little differently than our team and real estate brokers who are actually out talking with buyers and dealing with buyers on a regular basis. And really understanding the value and being able to look at those appraisals and decipher where they may have missed something or where the value really is extremely important. Some of the additional challenges we've run into when working with banks on their loss share agreements, we've found that there is hesitancy to get more aggressive at the end of the loss share agreements, for fear that the FDIC will push back, and they'll miss out on some of their recovery. But as Kate said earlier, if you're working with your loss share representative, your FDIC representative, and meeting with them and communicating with them closely, letting them know what your thoughts are, going over the plans with them, every step of the way, and as you get closer to the end of your loss share, and you have these assets and you're looking to get more aggressive, have the conversations with them. Our programs, part of our programs, we are continually doing VPOs. At the beginning of every program, it's extremely important that we look at the assets and provide value ranges, and we recommend that you sit down with your FDIC representative and go over those value ranges to make sure they're on the same page with where you're at. Most of our programs, we set reserve prices up front that we all can agree to, so that everyone's on the same page prior to moving forward, and then the FDIC is on board as well. Some recent case studies, we were involved last year, as Kay mentioned, with a bank that was nearing the end of their loss share agreement, and they opted to work with us to do an auction for a handful of those assets. And part of that process is we initially went through the list and evaluated and gave them a range before moving forward with the auction, and they accepted those ranges and went over them with their FDIC representative to make sure that those ranges were in line with what would be acceptable at the end of the program. It's also important, as we're talking about least cost alternatives, to go over some of the costs. Most of the costs in our program, we bear the costs up front, and then at the end, we get reimbursed marketing costs. People are always asking about marketing costs. We typically will advance the marketing costs, to run a program, and we get reimbursed those at the end of the program, and as well as a commission. In this particular case, the bank did include a handful of their non-loss share assets, which, as Kay mentioned, is extremely important to show the FDIC that you're willing to handle your non-loss share assets the same way you're handling your loss share assets. In this case, the assets range from a $10,000 piece of land to a $3 million hotel, and everything in between, from gas stations to multifamily, restaurants. It was all across the board and kind of scattered around the country. As part of the program, I think the biggest thing to take away from that was, we had the FDIC involved from day one. We provided, detailed value opinions at the beginning, where we looked at the appraised value and were able to explain to the bank and the FDIC why some of those appraised values weren't necessarily extremely accurate to what the real fair market value of those assets, were in on the sale date. This program, it was really a pretty fast program. It ran for about 60 days from start to finish. We advertised for about 4 weeks, and then we had the auction, got the properties under contract, and then closed them 30 days later. There was very little, if any, pushback from the FDIC. And going forward, I think it's important that the people on this call just understand that what your options are when you get towards the end of your loss share agreement. There are multiple options. It's extremely important to understand the value. I keep kind of getting back to understanding the value, because the decisions you're going to make to early terminate or continue and try to maximize your recovery really comes down to understanding the value and then having a plan in place. And even if you do opt to do the early termination, you're still going to have those assets left, and you're going to be selling those assets or working out strategies to maximize your recovery on those assets. So value is very important.
Great. So good holistic discussion, and we do have some questions. As a reminder, if you are on the call and you'd like to ask a question, certainly please do so. But we do have a number of questions, and we'll try to bang through them. So the first question, Kay, I'll throw it to you, just related to the process with the FDIC in terms of approval for selling certain types of assets or loans. As it relates to judgments, can they be sold without the FDIC approval?
Well, that's my understanding, yes. Now, I'm going to put a caveat on that. First of all, every note sale, not asset sale, but every note sale has to be pre-approved by the FDIC. And there are very few circumstances where bulk note sales can be approved, and that's when agreements specifically allow for it, and I think they're pretty limited to 1 or 2. And I had this conversation, and when a debt goes to judgment, it is no longer a note. And this discussion I had with our regional FDIC representative, and what I had understood in that conversation, because we were talking about doing bulk sales. You've got all this charge-offs and all these judgments and all these notes sitting out there, deficiencies that are worth nothing, and all they're doing is clogging up the system. And you still cannot, again, it was my understanding, you couldn't really sell the deficiency notes, although, well, that was definitely my understanding, but I think that's worth more conversation. The FDIC clearly wants here, they paid out, they spent 5 years paying out their share, and they want an opportunity to get it back, and that makes perfect sense to me. The judgments are different, and I think that, yes, I was told that we could sell judgments. I would not personally do that without another in-depth conversation with my regional manager on that, because I think you'd want to see there would be a difference about a judgment that where people actually have money and it's a substantial judgment, yep, versus all of these judgments that you have that aren't worth a nickel. So you would need to be able to do your least cost analysis on those. Does that make sense?
It does. It does.
Yes, you can do it, but you need to talk about it.
Yeah, I would say from a legal position that any proposed sale of judgment should be reviewed with the FDIC's representatives in advance that the prudent path would be to ensure that the FDIC was well aware of what the assuming institution had in mind, completely consistent with what Kay was saying.
Absolutely.
Great, great. So just kind of banging through these questions. This one's for you, Lori. Has the FDIC ever paid the assuming institution to get out of the loss share? Perhaps if a bank has numerous acquisitions with different dates, so all loss share coverage on each is removed?
Okay, that sounds like two questions to me.
Yep.
The first question, has the FDIC ever paid to the assuming institution? Absolutely. The overwhelming number of successful early terminations to date have involved the payment going from the FDIC to the assuming institution. Those, generally speaking, are cases where there's been some life left to the commercial coverage, and then, of course, there's the additional 5-year tail on the single-family coverage. So that has caused the payments, in most cases, to go from the FDIC to the assuming institution. The second question I heard was with regard to assuming institutions, loss share banks that have numerous FDIC failed bank portfolios, all of which, of course, have different failure dates. In my view, the real upside, the sweet spot for doing these types of early terminations is for banks that have multiple portfolios to make sure that they approach this as a package deal. You certainly wouldn't want a situation where you're early terming some of your portfolios and then maintaining others, because then you don't achieve those internal cost savings that I talked about earlier. So yes, you do want to do a home run here and negotiate an early term of all of your portfolios, both single family and non-single family. That's the home run both for the FDIC and the loss share banks.
Great, great. Okay, just continuing here. So Jeff, this one's for you, and then feel free, Lori, Kay, if you want to add any of your own thoughts. But just with difficult underlying assets, say golf course, land, vacant buildings, etc., and an auction is utilized and no offers come in at or above the reserve amount, then does the reserve amount sort of become the market value? How does that play out?
Well, let me just give a little background on our process, and then I'll defer kind of the accounting of it maybe to Kay. Typically, when we have a reserve auction or a reserve sale, we're not advertising that reserve price. We have agreed to that reserve price with our client, the bank, and a lot of times they've at least expressed that reserve price or shown it to their FDIC representative, so they're all on the same page. But typically we don't advertise the reserve price, and then kind of following it up, depending on the asset, if it's a golf course or if it's something, an asset where we don't feel like there's going to be a ton of interest, then that affects the strategy that we use, so that we can protect the underlying value and protect, the bank or the market. Typically in golf courses, depending on where they are, it's not something you're not going to get a ton of interest. You're not going to get, 100 people wanting to buy a golf course. So, a lot of those cases, we will have a reserve price with the bank, and we'll do a sealed bid or a date certain bid deadline where, the bids that are received are not out in the public for everyone to see. Now, if we get bids, and I'll use an example, if we have a sealed bid process and we collect bids and those bids do not meet the reserve, obviously the bank has the right whether they're going to accept the offer, the highest offer, or not accept it. It's a reserve sale, so we protect the client in that respect. In either case, if they do accept the price that's below the reserve, or if we get offers that aren't, I don't know the answer of how that has to be accounted for with the bank. Let's just say we got 3 offers that were below our reserve price. Does that affect how they have to show that asset on the bank's books?
No, and I think that's actually 2 separate questions up here. I mean, we had to market, based on what we thought that it would sell for as an accounting issue. as an FDIC loss share issue, it depends on the asset. For example, if you have a property that's only been owned by the bank for 6 months, or it's been owned for a year and a half, but you didn't market it for the first year, then that's one issue. But if you have, as you know that we did, properties that we've had in OREO for 5 years and been marketed and not sold, then the FDIC, for purposes of this, considered what people were willing to pay as the market price. Because in fact, it doesn't matter what it appraised for. If we had that marketed, if it were being actively marketed for 3 years or 4 years, the appraisal became irrelevant and everything else became irrelevant except for the fact that we finally had one person. And the fact that it was a nationally conducted auction. Everybody, public auction. Everybody had the chance to come in. So when you have a portfolio like that, that's really the issue. I mean, the issue is it's conducted nationally. It's public. Everybody has a chance to bid, and nobody buys it except that one person. Then that becomes your market. But I think, you know, an accounting-wise, you have the responsibility ahead of time to market
Roughly, yeah.
Your best guess of what it's going to sell.
That's great. Yeah, and I think we punched that question pretty well. So Lori, you know, in terms of just the early termination negotiation process, if you wouldn't mind just sharing some color in terms of just the negotiation, tonality, some of the things that you would just offer up in terms of preparation and whatnot that are sort of on the soft side of sort of this process, you know, that I think would be helpful.
Certainly. I think the bottom line is that for loss share banks, the ball is in your court. I described earlier some of the pilot programs that the FDIC as receiver conducted over the years, and in some of those pilot programs, they had very specific targets qualified to participate in that pilot program for early termination. As I described, those types of thresholds and qualifications no longer apply. Another learning that the FDIC accumulated over time with their pilot programs is that during some portions of their pilot programs for early termination, the FDIC as receiver offered of the potential early termination price for the consideration and review of the loss share banks, the assuming institutions. That, I think the FDIC decided was not the optimal approach, and so now the process is that it is the bank that offers that early termination price. Whether you are inside or outside the pilot program thresholds, in other words, whether your remaining portfolios are above $50 million each or below $50 million each, the onus and obligation is on the loss share bank to develop that offer, so to speak, that price at which you are willing to go forward naked. So ball's in your court. I urge all of my clients and every loss share bank that I talk to that they owe it to themselves, they owe it to their board of directors and their shareholders to, even if they like continuing going forward with this continued loss share insurance, even if they're comfortable maintaining it, they still have an obligation to look at this as a strategic option. And if they do consider it a potential strategic option, it then involves the internal process of determining what is that price at which the bank would be willing to continue to go forward with these assets without any continued coverage for losses or obligation to share recoveries. So Naveen, the obligation is on the part of the loss share banks to develop what that price is. As soon as you've got that price, you reach out to the FDIC and say, let's talk.
Let's play. Yep. And, well, this whole construct of the FDIC loss share arrangement is relatively complex. The process of going through and assessing and understanding whether or not there's opportunity to exercise an option for an early termination is one that banks have to go through. Navigating through those waters, and this is sort of a plug for the folks that are on the panel, to bring in a professional to help is certainly something that could make a complex process relatively easy. So that's the extent of the commercial I would give for the folks participating on this panel on their behalf. And so in light of the topic, we are 7 minutes to the hour. I think just to close, I would offer up an early termination to this webinar. We have a few minutes to spare, and I think it would be a great way to end our discussion. But before I do, I'd like to thank the panelists for taking the time to help prepare for this discussion and for being here with us today so that we can collectively share some insight with the marketplace. So, and then last but not least, those on the phone who dialed in, we do appreciate your participation, and we hope that you got something out of it. So thank you and have a good evening.